There we go. Thank you. So now I have the pleasure of introducing our keynote presenters for this afternoon's presentation, Ethan Welch and Janelle Leonard from Hickman & Lauder. Ethan is an attorney at Hickman & Lauder whose main area of focus is elder law, Medicaid planning, and special needs planning. Additionally, he focuses on general estate planning and trust and estate administration, as well as probate. His extensive knowledge of elder law and special needs planning ensures his clients' rights are protected and secures their future. Janelle is a licensed independent social worker with an advanced certification in hospice and palliative care. Her experience includes care assessment, care planning, and advocacy for older adults and people with disabilities. Janelle works closely with the attorneys at Hickman & Lauder to connect clients with a vast network of resources, recommend services, monitor clients' progress, and advocate on their behalf. Please join me in welcoming Ethan and Janelle.
Hello, thanks Ashley, and thank you to the Benjamin Rose Institute for allowing us to present today. Without further ado, I think we should get started because I jam-packed a lot of information in a short little time window. Just trying to cover as many practice areas as we can. I usually take about an hour or more on each subject. So it's a lot of information, but we'll be here to answer any questions after this presentation and in the next coming days or weeks. So just feel free to reach out to me or Janelle, and we'll be happy to answer any questions that come up later or just wasn't able to be answered today. So let's explain what an elder law and special needs attorney, really does. Estate planning is the key feature, and many attorneys classify them as estate planners. But an elder law and a special needs attorney, they do a lot more practice areas than just estate planning, as we can see here. A lot of special needs planning and a lot of Medicaid planning for the disabled and older adult population. We do a lot of guardianship and VA benefit planning. But because we deal with the vulnerable population, we see a lot of financial exploitation, abuse, and neglect, which ties into nursing home rights. So it's a large umbrella what we do, not just estate planning. And that's why we classify ourselves as elder law attorneys and special needs attorneys.
So just a few quick notes going forward throughout the presentation. So estate planning or advanced directives can be done at any age. And I stress that greatly. I think a lot of people think that you have to wait until you're retired or, much later in life to do any of this, but really you can start as soon as possible. And they can change and be updated over time as things change, as needs change, or as people come in and out of our lives. It's important to update those. For us, under the umbrella of special needs, we also include any client who not only has an intellectual or developmental disability, but also any physical disabilities. So sometimes we get individuals who maybe in their 40s or 50s had a spinal cord injury, traumatic brain injury, stroke, things that aren't covered under the DD services, but they still cause a physical ailment that requires unique needs, as well as mental health diagnoses. So going forward, that's sort of our umbrella of special needs. Kind of going back to what I said, the sooner the better. Putting advanced directives together keeps the decision-making in your hands. So I always say to people, it feels like kind of a morbid thing to talk about advanced directives, but it's so important to say, gosh, if something were to happen to me, this is what I would want done, whether it be with your finances, whether it be with your healthcare, whether it be with, your care in general. It's really important to do that. I tell our clients all the time, it's better to have a plan rather than deal with a crisis. So the sooner you start thinking about these things and start thinking about what you would want in the future, the better off you will be should something emergency arise. Also making updates. We have tons of clients who come in, they did some advanced directives back in the 80s. Now suddenly like things have changed and they haven't updated them. So please look at your documents. Like they're supposed to be a working document. So you're supposed to look at them and change them as needed over time.
Well, and that brings up a good point of, what are advanced directives? And, what I tell a client when I first meet with them, what is estate planning in general? A lot of people think estate planning is just doing a will or a trust. And well, that's one part of estate planning. Estate planning is planning for while you're alive and for when you pass away. So the advanced directive part is for while you're alive. So it's a whole host of documents. And you can see on this slide here, powers of attorney, that's healthcare and durable general powers of attorney that we also call financial powers of attorney. The living will, or the advanced directive for end of life care, mental health directives for the mental health community, HIPAA releases, HIPAA authorizations, letters of intent, and conservatorships, which conservatorships are in Ohio. That is a very, rare circumstance, and that's when the court is involved. And I'll get into conservatorship and guardianship in a little bit.
So just some quick notes on the advanced directives. So it is so important when you do come in to talk to us, or when you're thinking about these documents in general. One, you need to think about people that are in your life that you trust, that will honor your wishes. It's important to make sure that someone wants to be your person. I think a lot of times people come in and they go, oh, my daughter will do it. But did you talk to your daughter? Did you make sure that they're comfortable with that? And it's important to just have a conversation so they know what your wishes are and what you want and you do not want. It does not have to be a family member. You don't have to go in chronological order. You don't have to say my oldest daughter's first, then the next in line, because that might not be appropriate. It might be someone who's too far away or unable to be reached or anything like that. Or someone that you don't believe will follow your wishes should not be named in your documents. A common misconception is powers of attorney can go into effect when you want them to, or when you lack capacity to make certain decisions. For example, I took care of my Nana for a long time. She was alert and oriented. She had capacity, but when we went to the doctor, it was just too overwhelming. So she said, please talk to my granddaughter as my power of attorney so she can get the information and explain it to me later. Or banking. She said, please put this in place now so that I could help her pay her bills and do those things. But she still, she still had capacity. So it was really her choice to put those in place. You do have to have capacity to do advanced directives. So sometimes people come to us, and just having a dementia diagnosis or a developmental disability does not mean you lack capacity. So that's our judgment to sort of make, to say, do you understand what we're talking about? Do you understand what we're signing? Do you trust the person and know the person that you're naming? So we try to go through those things. It's a little different. I think some people think, oh, I have a dementia diagnosis, I can't do those now. And that's not true. And signing advanced directives does not stop your right to speak to doctors or financial institutions. Again, common misconception. People think, oh gosh, I put you in place as my power of attorney. Now I can't call the bank. And that's just not true. You are working with that person to meet your needs.
And another note on that, a power of attorney can be revoked at any time in writing or verbally. So if there is an issue, you can always call the bank and say, I don't want this power of attorney anymore on my file, and they're going to listen to that, and the doctor is going to listen to that, because there is no legal determination that you can't make that decision. The power of attorney is just a helping tool for that person, so they can appoint someone to help them. But that brings up the point of, how do we fight this financial exploitation with powers of attorney? You're seeing this more and more in the news now, where a power of attorney or a family member has stolen hundreds of thousands of dollars from their parent or grandparent or a family member or friend. Well, in the social worker, circle, Janelle's told me that they call financial powers of attorney these licenses to steal, which you can kind of understand why they say that. But a power of attorney doesn't have to be this license to steal. You can put protections in a power of attorney because this is a document that you're drafting. You can craft it however broad or as narrow as you want. The typical power of attorney that you get offline, yeah, that is a pretty basic power of attorney. It might not give you the protections that you want, but an experienced attorney, estate planning, elder law attorney would be able to, craft a power of attorney to meet your needs. And what do we do in our powers of attorney? We put in oversight provisions that if you want to put a limit on what can be spent, for example, if that you need to have permission from the principal or from some other party to make a large purchase. We also put a consenting parties provision in the document. So if there are certain things that you want other people to be in charge of looking over before the agent can make a decision, we put that protection in there. And remember, you are the principal is the one appointing these people as their agents. So obviously we want to make sure that this is an appropriate person to handle your affairs, whether that be healthcare affairs or financial affairs. And you can always revoke it. You can always revoke a power of attorney and get a new power of attorney if that would be the case. And then as part of our firm, we have Janelle on board as our care coordinator. She's our advocate for our disabled and elder population to, be that, feet on the ground for these people, to ask Janelle for their questions and concerns that Janelle can report back to another family member and say, hey, I'm not really sure what's going on here, but something's kind of fishy. Janelle, do you want to jump in and, add a little bit more?
Well, I think in addition to family members, a lot of individuals don't have a lot of family or are sort of isolated, especially since the pandemic. So they've really started to rely on some of their caregivers, paid or unpaid, to help with that. And one case that we did find, someone had done their estate planning and called us to change it to add their aid to it. And that's what sort of raised the alarm for us, was to kind of say, that's a little different than what you felt in the past. What's going on now? What's changed? So it's really all about communication. And that's why I say updating your documents and being in touch with the attorneys, as well as myself, to sort of say gosh, something new is going on or something new has changed. And we do try to watch for those sort of red flags.
Right. So
moving on to guardianships, when is a guardianship appropriate? So I work a lot with adult protective services in many different counties. And I think the easiest, the most common thing I hear is so-and-so needs a guardian, but it's not always appropriate. And everyone thinks that guardianship fixes everything, but it doesn't necessarily. So if there are no advance directives in place and a decision needs to be made, and someone lacks the capacity to make that decision, we might consider possibly a guardianship. So in other words, I use an example of housing. I think that's the most common thing. Maybe someone's living without water, without running water, without electricity. It's freezing cold out. They have no heat, and they're coming into the ER constantly, and they're having issues, and they keep saying everything's okay, but then this continues to happen. So they're lacking the capacity to understand what they're doing to try to help, and they continue going back to the same situation. So in that circumstance, maybe a guardianship would be appropriate. Documents like powers of attorney, we always ask for those first, because if you have a power of attorney, it can eliminate the need for a guardianship. So we'd much rather leave the control in your hands, have it be someone that you name to be in charge of your affairs or your wishes for healthcare, than have to turn to a guardian. If the individual's safety and well-being is at risk, if a reasonable decision is not made. So they, you know, and I go into lesser restrictive options have been attempted. We like guardianship as a last resort. We don't want to just go to guardianship necessarily. We want to give everyone an option to be able to make decisions. As adults, people have a right to make bad choices. They have a right to not, you know, keep their house as clean as someone else might feel it needs to be. They have a right to do those things. What we look at is their safety and well-being at risk. And that's when we kind of look at guardianship as appropriate. And this is especially complicated in situations with mental health. I know we face a lot. Family members will say, I need to be guardian so I can get them into an apartment. That doesn't mean you're going to sit at the door as their guardian and stop them from leaving. So that's where I say it's not always the best fix unless they're willing to cooperate. And sometimes that's tricky. So I always stress to people, we need to really look at what is your goal and would guardianship actually help you reach that goal for that person?
So Janelle talked about, you know, when is the guardianship necessary? So let's come to this point where, yes, a guardian is necessary to be appointed. These are the key terms for you to understand about a guardianship in Ohio. You know, the guardian is the one that is applying to be the court to become this overseer over the ward. And then once the court has all the information in front of them, the application, the doctor's opinion that this person needs a guardian, and they have the investigator's report, an investigator comes out to visit with the ward to explain rights and circumstances, the probate court makes a determination of, you know, incompetence. And only the probate court can determine incompetence. So there's a lot of misunderstanding in the medical world, the legal world, and the layperson's world, you know, the difference of these terms of incompetence and capacity. So capacity can come in and out. You know, at one point, a person might be able to be lucid and understand and sign. But then, you know, a few hours or, you know, a few days later or a few weeks later, they don't have that capacity anymore. Incompetence is constant. That's a legal term that the court, after gathering all the evidence, they determine, yes, this person is incompetent. They need a guardian placed to oversee their financial or healthcare decisions.
A quick note on that though, guardianships can be terminated if someone gets a guardianship in place for, let's say, a mental health crisis, and maybe that takes 2 or 3 years. If 2 or 3 years, they end up stabilizing on medication and following through with treatment and things like that, and they're no longer deemed incompetent by their doctor, you know, labeled incapacitated by their doctor, and then the court finds that they are no longer incompetent at that time, they can terminate that guardianship.
Right. It's not a, you know, it's a semi-permanent, you know, declaration. It could be hard to get rid of guardianship, but if the evidence is in front of the court that this person does not need a guardian anymore, they will, you know, terminate the guardianship. And it comes up once in a while. I think I probably get, you know, 1 or 2 a year where we terminate guardianships. The circumstances have to be right for that. So Janelle kind of touched base on this a little bit, you know, why we need a guardianship, you know, financial reasons, healthcare, medical reasons, you know, placement and housing is a big issue for our whole community. If they need to go to a facility and they're not safe at home, the guardian can place them in a facility. And programming, you know, with you know, benefits with the DD board, and education. If the person is young and still in school, I'm thinking of the transition age at 18, in early 20s, that the guardian is in place to, help with schooling and speaking to the school districts. Then we have the types of guardianship. So obviously we have the natural guardian. That is the parent of the individual, of the child, age 0 through 17. Once that child reaches 18, they are considered competent to the law. If this person is not competent and needs a guardian at age 18, you have to file for the guardianship. In Ohio, it's generally a guardian of person and guardian of the estate. Guardian of the person deals with medical decisions, placement, and the education. Guardian of the estate deals everything with financial, including real estate, bank accounts, money. Then we have these other terms here: the limited guardian, interim guardian, and emergency guardian. These don't come up, as often, and actually pretty rarely. But you can petition the court that you want to be a limited guardian for a certain thing. If you apply to be a limited guardian or an interim guardian is for a certain time period. So limited guardian is for a certain thing, interim guardian is for a certain time period. The court might say, yeah, we know you applied for this limited purpose or this limited time period, but we're going to appoint you guardian anyways because the circumstances need that. The emergency guardian is for imminent need. So a lot of people think that it's an emergency, because they're not making a good decision and they don't like that decision. So it's an emergency to help. In our experience, an emergency is essentially they need this medical procedure or they're going to die, within hours or days. So one facility one hospital even told Janelle and I that this person needs to be bleeding out before a doctor will sign off as for an emergency guardianship. It's an extra form that the doctor needs to fill out that says that this is an emergency, it's an imminent need. It's very rare that we ever go through this, but the emergency guardianship can be established that day, and then there's multiple hearings involved. It can happen, and I've been through the emergency guardianship, but it is a rare circumstance. Remember, the probate court is the one appointing the guardian. It's the ultimate superior guardian over the ward. So the probate court can always remove the guardian and replace the guardian. And if the guardian let's say the guardian would pass away and there's a dire need for the ward for a healthcare decision or a placement decision, well, the probate court can place the ward on their own behalf before they can appoint a new guardian. So the probate court is always the one in charge.
So same as guardianship, it is for power of attorney. Whoever is named as someone's guardian should understand what the ward's needs and wishes are. And it might be someone, we do have adult guardianship services in the Cuyahoga County area that sometimes gets appointed for an older adult who needs placement or things like that. It's important for them to talk to them, find out what they want, what's in their best interest, and you try to make those decisions based on that. And again, we always want to try the least restrictive if we can. And if it fails, then we move on to something else. But you should be a guardianship should meet with their ward at least quarterly. Now with the pandemic, that changed. A lot of people were not, we have had wards that have been in facilities. We weren't allowed to visit unless we were immediate family and things like that. So there was a time frame where we could not see them, but at least checking in with the staff, care conferences, things like that. And we're always looking at person-centered planning. So you always want to make sure that that ward is at the center of your decision-making.
Yeah, and just so people know this, that, you know, if there's ever a disagreement with the ward and, you know, and the guardian, or a family member of the ward and the guardian, the court is always there to hear, you know, hear the complaints of the ward and the family members, and they actually call it a complaint form. So you can always petition the court to, you know, to hear them, hear their thoughts and concerns. Every court, every county, it has a little different mechanism, but it's just because a guardian chooses to do something doesn't mean that it might be the most appropriate, you know, way to do things. So it's, the ward always has a say, and family members have a say. So it's just, you just need to look at the local rules and petition the court.
Now, there are some special considerations with mental health. So they can sign powers of attorney. Sometimes, unfortunately, with mental health, it is a tricky situation. If someone is lacking capacity, you know, we would make sure they understood what they were signing. But if they did sign a POA, they can also revoke that at any time. So it's a little bit trickier for some of our parents of adult children with mental health issues. If they do become institutionalized or in a psychiatric hospital, if that individual says no to the doctor that you cannot speak to my parents, then they cannot speak to the parents. They must follow the patient wishes because the patient has not been deemed incompetent. Even if in that moment, you know, they're having some issues and they have not taken medications and they're not, they don't have capacity to make decisions, that still doesn't matter. They still have not been deemed incompetent. This can be very frustrating for families, probably more so than anything. They can complete a declaration for mental health treatment. This gives specific instructions on treatment options and medications. It also clarifies HIPAA instructions. So it'll say, gosh, even if I come into a hospital and I say, don't talk to my mom, I still want you to talk to my mom because I'm filling this out while I'm lucid and I have capacity. And I know that if I end up in a psychiatric unit, that means I don't have capacity at that time, you know, for myself. And so I'm asking you to continue to talk to them. So I haven't seen these a ton. I mean, it does exist and we've helped people complete them and they do get updated. I think it's every 3 years, but it is a great option if you are working with someone with a long-term mental health issue, like possibly schizophrenia, bipolar, those types of things, to kind of help guide people to help them better. Sometimes the only option for mental health clients is guardianship, even if it's, you know, short-term or like for an interim period of time, or if it's for a specific reason. But you can still keep your power of attorney, you know, who you've listed if that has not been revoked.
Yeah, just to clarify, the mental health directive is, you know, when you sign that and then you have a mental break and you're in the hospital and you say, no, I don't want this treatment, or I don't want you talking to my mom or my parent, the doctor can say, well, no, you signed this mental health directive. It's in effect, even though you are trying to revoke it. So it is a useful tool for our mental health, you know, clients. So now we're going to switch gears and talk a little bit about Medicaid, and particularly what we're going to talk about with Medicaid is for our older population. If they need more care and need, you know, Medicaid services in either a facility or in the home, that's what we're going to talk about. But there's a lot of overlap with Medicaid rules with our disabled population and our elder population. But let's just dive in right here. So my first question to clients that I meet with are, you know, are you single or are you married? Because rules are different for our married applicant compared to our single applicant. And the terminology here is the spouse that needs Medicaid is called the institutionalized spouse, and the spouse that doesn't need Medicaid is called the community spouse. They're in the community, living in the community. Resources and income are treated differently for married couples. So a married couple's assets are considered together for Medicaid purposes. So it doesn't matter if it's a joint account or an individual account, it's considered a marital property for Medicaid purposes. Income, though, is treated differently. Income to one spouse is that spouse's, and income to the community spouse is that spouse's. So that's very important to understand as we move forward. The bottom line, though, is Medicaid does not want to impoverish the community spouse. Medicaid rules are very clear about that essentially they don't want a married couple to spend all of their resources on a facility, and then shortly thereafter the community spouse needs Medicaid as well because their assets are gone. They can't take care of the community spouse as well. So now Medicaid is paying for Medicaid for both spouses. That's what Medicaid is trying to avoid. So here's the basics with resources. A single applicant can only have less than $2,000 to qualify for Medicaid. A married couple gets 1/2 of the snapshot countable resources with a minimum of about $27,000 to a maximum of about $137,000. So let's just, quick example here. We're talking about countable resources, and we'll get into exempt resources and what in a second. But let's just say we have $100,000 in cash between the two spouses. If you take 1/2 of that, that's $50,000. $50,000 is protected for the community spouse right off the top. If it's $200,000, that's $100,000 protected for the community spouse. If there's $500,000, the maximum is the $137,000 that's protected for the community spouse. The snapshot date is the first day of the first 30-day period of institutionalization. So that means if a spouse goes to the hospital, then goes to rehab, then has to go to the nursing home, it's the first day of that hospital stay that Medicaid takes a picture of your assets and determines, okay, this is what they own at that point in time. And you might not need Medicaid for another year, but they take a snapshot of that first day of institutionalization. And that's important to know when we apply for Medicaid. I'm going to go through these next slides pretty quickly because we have a lot to cover. But these are important slides about Medicaid that I think everyone should know. And this pertains to our disabled clients and our elderly clients. So there's a host of exempt resources, but these are the main ones. These are the most valuable exempt resources, and that's a house, the residence, one car, irrevocable funeral contracts, your personal belongings, those are all exempt, assets in a special needs trust or a pooled trust, and a life insurance policy with a cash value of less than $1,500. Income basics, like I said, income is treated differently than assets. So income to a community spouse is theirs. Income of the institutionalized spouse, that's called a patient liability. So if the spouse goes to a nursing home, the income is essentially paid to the nursing home. You get to deduct medical premiums, and the institutionalized spouse gets to keep $50 a month, but the rest goes to the facility. The community spouse may be able to receive some of the institutionalized spouse if there's a discrepancy, a vast discrepancy in income between them. But it's a case-by-case basis. This is a very misunderstood term, the look-back period. So what the look-back period means is Medicaid is looking back 5 years from the date of Medicaid to determine if there's been any improper transfers. An improper transfer is a gift. So for every $6,905 that you've transferred to a child to your church in the last 5 years, that is 1 month of a penalty period which means Medicaid is not going to pay for that month. So a $69,000 gift is a 10-month penalty period that Medicaid will not pay for. So we account for gifts. We might do an intentional gift before a Medicaid application, but this is what a look-back period means, is if you've done a gift, they will penalize you within the last 5 years. Here's some exempt transfers that are important to understand. Transfers between spouse for the residents, for a child under the age of 21 or is blind or disabled, those are exempt. That's an exempt transfer. A caregiver child is exempt if the child has been living with the parent. And a little known fact that if a sibling has an ownership interest in a house and has been living in the house for at least a year, that's also exempt. There's all other transfers that are exempt. If you have a disabled adult child, I always tell my clients that if you ever need Medicaid, you can always transfer assets to a trust for that disabled child or to the disabled child directly. So, and you can get on Medicaid, that day. It's an exempt transfer and it's right in the Medicaid rules. Residence for a single applicant, the good news is that is exempt while that person's alive. The bad news is if that person's on Medicaid and still owns the house, it is subject to a Medicaid lien, and that acts like a mortgage on that property. So we always account for the house when we're doing a Medicaid application, so everyone knows that the house is subject to Medicaid if it's still owned. Then we have Medicaid waiver programs. A Medicaid waiver is, it allows for our disabled population and our elder population to receive services outside a facility and still be on Medicaid. So there's more community involvement with the waiver program to allow more financial freedom, a little bit more just freedom in general. So our developmental disabilities waivers are the IO waiver, the level 1 waiver, and the self waiver. They all have different, different things that are allowed. The IO waiver is the best, then the level 1, then the self. Those have just changed July 1st. So Ohio actually added more benefits to those waivers starting just this month. Then we have our other waivers for our aging population that allow Medicaid in facilities such as assisted livings or Medicaid in the home, which is called Passport. So you can receive services in the home being on Medicaid. The financial requirements are all the same though. Then I'm going to spend a few minutes here on the last 8 or so slides about special needs planning. Essentially, special needs planning is, here's our list of tools that we have. Some clients use all of these tools, all of these trusts and accounts. Some clients only use one. It all depends on the circumstances. First, we have the first party trust, which is called a special needs trust or a D4A trust. These are trusts that the beneficiary has owned or had possession of. And I'm thinking of these items like litigation proceeds or an inheritance that they are legally entitled to. Well, if they receive this money, they will lose their Medicaid benefits. They have to go to a special needs trust, a first party trust. Here are the basics of it. It can be established by these individuals. It can be, you have to be under the age of 65 and considered disabled. There's a Medicaid payback provision in this trust. So any money left in this trust at the person's death is paid back to the state of Ohio or any state that they've received Medicaid benefits. Then we have third-party trust. This is what we use for our estate planning purposes. This third-party trust is our trust that it works just the same as a first-party trust, with one major exception. There's no Medicaid payback provision. So the money that you set aside for your disabled adult child or disabled child, if that beneficiary then passes away, the money in this trust stays in the family, or it goes to a charity of your choosing. You decide where this money goes to. It does not go back to the state of Ohio. The reason for that is you are setting this money aside for the beneficiary. The beneficiary has no legal ownership over this money. The trust does, even though they're the beneficiary of it. Stable accounts are administered by the Ohio Treasurer Department. They're enacted by federal law called ABLE, the ABLE Act. You can contribute up to $16,000 a year. If you're employed, you can contribute an additional $12,880. People ask me, well, why do I need a special needs trust? Why can't I just use a stable account? Well, it's because of these contribution limits that restrict that. Plus, it has a Medicaid payback provision, but it's similar to a special needs trust, but it's a little different. It's to the point of opening the account. That's the Medicaid payback provision. So it's a useful tool, stable accounts, because you can use it for food and shelter purposes, which our SSI recipients, there's a lot of restrictions for. And overall, it just gives a lot more financial freedom to our disabled population so they can use their stable account for whatever they want, whatever they need. They can purchase those items without having to relying on their trustee or their parents to spend money. Well, if they fund the stable account, well, they have a card, they can go use money and however they want. Then I wanted to, just touch base on pooled trusts. They work just like a third party and a first party trust, but it's managed by a nonprofit organization. And the nonprofit that we use is Community Fund Management Foundation. They're based out of Middleburg Heights. They are a nonprofit. They manage, over $100 million of disabled and elderly clients' money for them to then receive Medicaid and benefits. So in Ohio, an elderly over the age of 65 can contribute to this fund. Obviously we're dealing with a nonprofit, so there's issues with red tape and getting that money in a timely manner. But for a lot of people, this is our only option for them to retain their money and also retain their benefits. So like I said, I rushed through a lot of that so we can pack it all in, the Medicaid and the special needs estate planning. I believe that we might have some Q&A, some questions here.
Yeah, thank you, Ethan and Janelle. We do have time for a few questions from the audience. Please remember to submit your questions using the questions box in the control panel on the right-hand side of your screen.
So I'm just going to go in order here with our questions. So what is meant by the ward? The ward is the person, the disabled person that needs a guardian. People say they're the ward of the state. Well, that's not entirely accurate. A ward is just the legal term to the person that needs the guardian, needs the guardianship. So we have the guardian overseeing the ward and the probate court overseeing everyone.
I can take the next question. The question is, hello, I understand New York is the sole state that allows for adult adoptions. Is that an option that's recommended in lieu of, say, guardianship? Say, for example, the purposes of combining two households. I work as a social worker at New York, I'm guessing housing. Thank you in advance. So I don't know if New York is the only state that allows adult adoptions. They're not super common. The difference between that and, say, a guardianship is adult adoptions, the person that's being adopted consents to it. In a guardianship, and I don't know exactly how it works in New York. What we talked about today was in Ohio, but in the, a guardianship is someone else is saying someone needs a guardian. That person is not necessarily consenting. So that's why anytime you can do something less restrictive, like an adult adoption, yes, that would be great. Anytime you can do that as opposed to a guardianship.
Next question is, how long does the guardianship and POA process take? If a person's able to sign a POA, it's as soon as they can get in front of a notary and have the POA drafted, and that could be, hours. It could be days, whatever it takes to, get to that meeting. Guardianship, on the other hand, in Ohio, it generally takes from the moment you receive the court receives the application and the doctor's opinion, called the statement of expert evaluation. It takes about 4 to 6 weeks to get a hearing date. So in that 4 to 6 week time period, a court investigator will come out and visit with the ward, explain the alleged ward's rights, that they have a right to contest, they have a right to their own attorney, they have a right to their own independent evaluation. But it's generally 4 to 6 weeks out. It really depends on the county and the county workload at that point in time.
The next question is, I work for the New York City Housing Authority, and we have an elderly tenant who has been in a nursing home for about 3 years. He has a community guardian. They have not paid the rent in all that time. I've been in touch with the guardianship agency, but they still do not comply. What can be done? So if this was Ohio, I would say immediately contact the probate court. I believe in New York, I feel like, I know it's a court. I'm not sure if it's probate court or if it's their county courts. I'm not sure how it works exactly, but the court should be able to investigate and look into that guardian or that guardianship program. I don't know if it's someone who should be on Medicaid, and maybe there's a holdup with Medicaid, and maybe that's why they're not getting like their patient liability. I'm not totally sure how it works in New York, but I would say at least start there with the court and have them investigate to see why that's not being done.
So next question was, are these Medicaid requirements for only Ohio? And so that brings up, even broader, answer for you, that Medicaid is a federal program. Everyone pays into Medicaid, but every state has, different rules of how they manage Medicaid. So, some states allow for 24/7 caregivers to be paid for, all ages. In Ohio, for example, Medicaid only allows for 15 to 20 hours a week for caregivers if you're on that passport program. So every state can limit or broaden Medicaid. So to answer that question, what I gave you was what Ohio requires, and so every state is a little different. The next question here is caregiver child and adult child in the home caring for the applicant? Yes. So in Ohio and many other states, this caregiver exception means that if they have lived in this home for 2 years prior to Medicaid, the house can be transferred to the caregiver child. So you have to have the documentation in place, and you have to prove that you've been in the house caring for your adult parent, but it only matters between child and parent, not person and niece, not person and friend. It's a child caregiver exception.
Thank you. It looks like we have time for one more question.
Okay.
Sorry, I'm trying to read quickly.
I know.
I know there's a lot of other states, and I know
that
it's hard because everything we gave you is kind of Ohio specific. Sorry.
Here's a quick answer for what are implications if a couple divorces to protect assets? That is a strategy when you're applying for Medicaid that some people consider. However, Medicaid rules say if you divorce, there has to be an equitable division of assets. So that means if you have $500,000 that's marital property, $250,000 would have to be split down the middle. So you're subject to a $250,000 over resources for the community spouse then. So, I hardly ever recommend a divorce. It's very limited to when you're applying for Medicaid.
And for those questions that we didn't get to, we will collect them and we will obtain the emails from each of those persons that asked the questions and send them over to Hickman & Lauder, and they'll answer you directly. So we are running out of a little bit of time, and we'll pass it over to Ashley for some thank yous.
Yeah, so thank you, Janelle and Ethan. It was a really great presentation. We appreciate you being here with us. Before we conclude today's webinar, Project Director Branka Promenica is going to tell you briefly about BRI Care Consultation, a care coaching program available for families impacted by dementia in various counties in Ohio through the Administration for Community Living Project. Branka?
Yes, thank you, Ashley. So Hickman & Lauder is definitely a wonderful resource for all of you to seek out, tell your clients about, etc. If you are looking for additional resources, I'm going to talk a little bit about BRI Care Consultation. BRI Care Consultation is a telephone-based and email-based care coaching program. And with this project, this Administration of Community Living project, it's for individuals either at risk or with dementia. So at risk is the key. So it they don't have to have an official dementia diagnosis, and also including persons with intellectual and developmental disabilities and their family and friend caregivers or other support. This program is available at no cost, and I'll tell you where the service areas are in a little bit. But before I do, I'm going to talk a little bit more about the program. So essentially, each family or individual is assigned a personal care consultant. And this is, again, it's a program that really helps to identify immediate, and then once immediate needs are addressed, future needs of individuals and families. So it could be connecting or getting the community services, helping develop a step-by-step plan. So if it's something that, there's some legal needs, definitely linking to those legal resources, such as Hickman & Lauder, to be able to help out and kind of guiding you through that process with, providing that supplemental information, communicating with loved ones. And so getting families on board to really share those responsibilities, staying in touch with individuals and families, getting other family members involved, and just being there as an emotional support. So this is an ongoing program. So it's not just a one-time referral. It stays, this program stays with you for as long as the caregiving situation needs and evolves. So this is our service areas within the Administration for Community Living Grant. You have here the counties of Cuyahoga, Lake, Geauga, Lorain, and Medina counties, served by Benjamin Rose Institute on Aging under the name of We Care Because You Do. And then also at Welcome House. Notice the little asterisks, little stars. It means that those agencies do serve individuals with intellectual and developmental disabilities. We also have in Washington County and also Woods and Pleasant in West Virginia, O'Neill Center, and then United Seniors of Athens County and Athens County, Ohio. If you are outside of these service areas, please do give Benjamin Rose Institute on Aging a call and ask for We Care because we may be able to link you to other programs across the country or give you some other options where you can receive this program. And that is it for my presentation. Back to you, Ashley.
Thank you, Veronica. We want to thank you again today for joining our Legal and Financial Planning for Older Adults and Persons with Disabilities webinar. A recording of today's session will be made available at www.benrose.org on the event registration page and in our resource library. We are offering more webinars like this for community organizations and families impacted by dementia each quarter of this ACL project. To stay up to date about our upcoming webinars, please visit our website. Again, that's www.benrose.org. In the chat,
go ahead, Ashley. I thought, okay, go ahead. You mentioned it.
In the chat, you will see a link to a post-session questionnaire. You will also be receiving it via email later today. We just ask that you please complete the post-session questionnaire within 1 week following today's session. Your responses and feedback will be used to show the impact of programs like these and to improve the tools and resources provided to individuals living with dementia and the people who support them. Thank you again for joining us and have a great rest of your day.